Hello and welcome back to Ganga Education. On this platform, you will find quality lectures related to field of law, competitive examination in legal domain, important legal facts and legal history, all explained in clear and structured manner. In today's session, we will discuss on important topic under evidence law, that is definition clause.
In any court case, everything really boils down to one simple thing, a fact. So today, we're going to get right down to the basics of Indian law to understand what a court actually considers to be a fact. It's the foundation for literally everything.
So let me just ask you this straight up. In a court of law, what is a fact? Now, you'd probably think the answer is simple, right? Something that's true. But in the eyes of the law, well, it's a whole different story. And frankly, a much more interesting one. You see, for a lawyer or a judge, a fact isn't just, some universal truth. It's the actual raw material, the building blocks for every single argument and every piece of evidence. Understanding this specific definition is the very first step. So let's get right into it. What does the law actually say? We're going to look directly at the Adhiniyam, the Act itself, specifically Section F, to see how it defines a fact.
And here we have it. The law basically splits a fact into two very simple ideas. First, you've got anything you can perceive with your senses, what you see, hear, or touch. Simple enough? But then there's the second part. Any mental condition that a person is conscious of, like a thought, a feeling, or an intention.
And this slide, wow, it just perfectly shows the two sides of the coin. On one hand, you have the external physical stuff. You can literally see those knives arranged just so. That's a fact. But on the other hand, you have the internal stuff, a feeling, an opinion, something only that person is really conscious of. And guess what? The law says that's also a fact. Okay, to make this super clear, here are a few examples. The way objects are placed in a room, that's a physical fact. Someone hearing a shout, also a physical fact. But here's the tricky part. Someone intending to do something or acting in good faith, those are mental facts. And the court has to deal with all of it. All right, so we've nailed down what a fact is. But come on, in a big court case, not every little fact matters, right? So which ones are the important ones? That's where we get to our next big idea from Section G of the Act, facts in issue. And to really get our heads around this, let's take a look at a pretty serious example, pulled straight from the law books. Picture this. A person, let's call him A, is accused of murdering another person, B. So, what exactly are the facts in issue in a situation like this? Well, think of them as the main questions of the entire case. They're the things the judge must answer to reach a verdict. Everything else is just background noise. The answers to these questions decide everything. So, for our murder case, these are the big questions. The facts in issue. 1. Did A actually cause B's death? 2. Did A intend for it to happen? 3. Was A provoked? And 4, was A in a sound state of mind at the time? The entire trial, every piece of evidence, every witness, it all comes down to proving or disproving just these 4 things. Okay, so we have our big questions, our facts in issue. But how does a court figure out the answers, especially for something you can't see, like someone's intention? Well, the law gives the court a really interesting tool to work with. We find this in Section H, and it's called the power of presumption. This is what's called may presume. And it's basically a kind of legal shortcut. The judge has a choice here. They can look at the situation and say, you know what, I'm going to assume this is true unless someone can prove to me that it's not. Or the judge could say, nope, I'm not convinced. You need to bring me more proof. And these presumptions, they aren't just pulled out of thin air. They're usually based on, common sense and life experience. For example, the way the law thinks about children, that's a perfect example of this. Let's look at a specific rule, Section 83. It says that for a child under 12, a court may presume that the child doesn't really have a mature understanding of what they're doing. So that's the starting point. The court can begin with that assumption. But, and this is important, it's not the final word. The other side can still bring evidence to show that actually this particular child was mature enough. See, it's a starting assumption, not a hard and fast rule.
So let's just tie this all together. It's actually a pretty neat logical flow, isn't it? We start with a basic fact, something you can see or something you can't. Then we zero in on the really important ones, the facts in issue for that specific case. And finally, to figure out those key facts, the court has tools it can use, like presumption. See how it all builds up?
And all of this leaves us with a really big question, doesn't it? If facts can be things we see, but also things we can never see, like a thought, and if courts can sometimes just presume some things are true, how does a court ever get to the real truth of what happened? It's a tricky question, and definitely something to think about.
Thank you for watching this session. If you found this lecture useful, do like, share and subscribe to Ganga Education. Keep learning, keep growing.